Warm welcome everyone to this panel on Friday, the last day of the conference. My name is Livia Johannesson, and I'm a researcher from Stockholm University, and I will be sharing this session and introducing the presenters. Okay, so the theme of this session is fairness and access to justice, and we have what I can see now, two presentations, very interesting presentation dealing with this issue from two different European countries, Poland and Ireland. We thought we would have Greece here as well, but I think no. So this topic is very interesting, and it has interested me for a long time, since it encompasses two concepts of major importance for this field, namely fairness and justice. And I think it's also interesting that these concepts, in what way are they combined and in what way are they separated? I have spent some years trying to figure out what these concepts mean in different contexts and how they relate to one another and how they are used for political purposes or other purposes, and what kind of normative underpinnings they are based on. Then I hope we can have the opportunity to discuss this more in the session, in the Q&A as well. Without further delay, I want to present Maya Licencia, an attorney of law and PhD candidate from the University of Zurich, Switzerland, and Warsaw Bar Association in Poland. And she will give a talk with the title Access to Justice for Asylum Seekers Staying in Poland. Maya Licencia is a Polish attorney of law who worked for many years as an immigration lawyer in the Helsinki Foundation of Human Rights in Warsaw. Currently at the University of Zurich, she is finalizing her PhD thesis on asylum cases decided by the European Court of Human Rights and the Court of Justice of the EU. She is also co-author of the IDA report on the Polish asylum system, published yearly since 2013. So please, Maya, the floor is yours. I think you want to share your screen, right?
Yes, I do. Thank you, Livia. Welcome, everybody. I will share my screen. Welcome, everybody. I would like to speak today a little bit about the access to justice for asylum seekers staying in Poland. I will concentrate on the right to an effective remedy as it is understood under the European Convention on Human Rights. In particular, I would like to show you how the suspensive effect of remedies is shaped in Polish system. But before I do that, as we have international audience, I would like to tell you very shortly about asylum seekers in Poland. As you can see from those statistics, I hope you can see now, Poland is not very popular with asylum seekers. We have 4,000 to 5,000 applications per year. It's comparing to other European countries, very small numbers. Of course, in years of refugee crisis, the numbers peaked, but still they were quite low comparing to other countries. And in the pandemic year 2020, we have the lowest number of asylum applications in many years in Poland, due to pandemic itself, but also due to measures that the Polish authorities took to fight pandemic. At least this is what they said, that those are the measures to fight pandemic. Second observation that we can make here is that Poland has very low recognition rate. It is really difficult to be granted refugee status or subsidiary protection in Poland, and asylum seekers really struggle with proving that they're really in need of protection in Poland. We have 3 asylum-related proceedings in Poland. Of course, asylum procedure, but also refusal of entry proceedings, which are used by Polish authorities to push back asylum seekers from Polish border. and return procedure, which is of course applicable to rejected asylum seekers, but also presumptive asylum seekers, and sometimes it goes in parallel with asylum proceedings, as you can see later on. What is a common feature of all those proceedings in Poland? There are all what we call in Poland administrative proceedings, which means that they have the same structure. They always start with the administrative authority of first instance, then first appeal is considered again by the administrative authority, another one, and next only then the asylum seeker can approach courts, administrative courts. There are two courts which are responsible for that. It's Voivodeship Administrative Court in Warsaw, and next Supreme Administrative Court also in Warsaw. I will start with refusal of entry because I believe that this is one of the biggest problems we have in Poland with the refugee protection. And the best example to show what's happening in Poland is the case of Terespol. Terespol is a border crossing, train border crossing with Belarus. And for many, many years, it was a main entry point for asylum seekers in Poland. The biggest numbers of asylum applications were lodged at this border crossing. So this is very good example to show what's happening there. And what's happening there, in fact, is that asylum seekers board a train in Brest in Belarus. They go for a very short ride, and they come to the border crossing. They approach border guard officers, and their documents are checked, obviously, whether they have visa or not. If not, they are asked to go for additional interview. And here is the moment where, at least in theory, they can ask for asylum. Unfortunately, asylum seekers' claims are often not heard at all, or they are selectively heard. So to give you an example, the asylum seekers comes and says, I need asylum, I would be in danger if I go back to my country of origin, I will be killed. Any story which we hear all the time as asylum immigration lawyers. And then he will add, and you know, my brother is already in Poland, so I would like to join him. And then in the documents which border guard officer writes after such interview, only the brother will be mentioned, and the fact that the asylum seeker didn't have any visa to cross the border. So in those circumstances, refusal of entry decisions are issued instead of registering the asylum application. And asylum applications in practice are registered only after multiple attempts to cross the border. By multiple, I mean even 10 times, 20 times, 30 times. Depends how determined the asylum seeker or asylum family is to come every single day at this border crossing and saying the same story and hoping that this time they will manage to register their asylum application. And some asylum seekers manage to have their asylum application registered straight away at the first time they approach Terespol border crossing. Others have to go through many attempts. Of course, those actions or inactions of the border guard are completely unlawful. They are against the principle of non-refoulement, international law, EU law, but also Polish law, which directly says that asylum seeker, if the asylum application is the will to register asylum application is made at the border crossing, the decision on the refusal of entry cannot be issued. And moreover, border guard is not the authority which makes decision on international protection in Poland. We don't have border guard procedure. We have border guard has only technical responsibilities within the asylum proceedings. I mean, they simply have to register the application and send it to the authority who is responsible for making a decision. So asylum seeker, obviously, if he receives refusal of entry decision, can make appeal. He can appeal first to the chief commander of the border guard and next to the administrative courts. However, those remedies are not effective at all. There is no suspensive effect attached to those remedies. And asylum seeker, even if he is so knowledgeable, he is so determined to make the appeal straight away after receiving the decision on the refusal of entry. So on the board, at the border crossing in Terespol, he still will be made to board the train back to Brest in Belarus, and he will have to wait for the results of the appeal proceedings in another country, not in Poland. There are great evidentiary difficulties in those proceedings because this is a word against word situation. The asylum seeker says, yes, of course, I said I want asylum, I'm in danger, I cannot go back to my country of origin. And the border guard officer says, no, he never said that. And that's all. There are no witnesses, external monitors there is legal representatives are not allowed to participate in those interviews. There is no audio video recording of those interviews. So there is basically no way to prove what really happened there and who said what during this interview. What's even the worse, there is no guarantee that the asylum seeker will be allowed to enter Poland when the court annuls the challenge decision. So basically, starting the appeal proceedings is somehow nonsense because there is no effect which the asylum seeker would like to, so entry to Poland. And all those problems were noticed last year by the European Court of Human Rights in MK and Others versus Poland case, where the court found the violation of Article 13 in conjunction with Article 3 of the Convention and Article 4 of the Fourth Protocol. What the court said very clearly that in Terespol there is a systemic practice of misrepresenting the statements given by asylum seekers. There is a lack of proper investigation into the reasons for which asylum seekers seek entry into Poland, and most importantly, remedies have no suspensive effect. So moving on to judicial remedies in asylum proceedings, I already started to speak a little bit about the asylum proceedings. They start with border guards, but as I said, they have only some technical responsibilities. The decision is made by the Office for Foreigners. Then the asylum seeker may appeal to Refugee Board, and such appeal has automatic suspensive effect, so that's good. Next, he can approach courts, and here suspensive effect is not attached to the further appeal. It must be requested, and the request is non-suspensive. In the request, the asylum seeker must show that the enforcement of the negative asylum decision will lead or can lead to the irreversible harm. And as you can see, suspensive effect is often denied by the courts in Poland. The main justification is that the negative decision in asylum proceedings is not directly entailing removal. There must be return proceedings afterwards, in general at least, which will lead to the removal, and in those proceedings the suspensive effect can be requested and granted. At least this is what the court says in the decisions given within asylum proceedings. And the truth is that it is very unpredictable in which cases the court will grant or not grant suspensive effect. It feels like it depends on the judges who are deciding about that, and the interpretation is not, judges, I would say, differ as regards, have different opinions as regards the suspensive effect in asylum court proceedings, and it shows in their decisions. What happens next? The negative refugee board decision, so second instance decision, entails obligation for asylum seekers to leave Poland in 30 days. If they do not do it, then there are, of course, illegally on the Polish territory, and return proceedings may be initiated. It means that asylum court proceedings and return proceedings may be going in parallel, and it may happen, and it happens in practice, that the return decision is issued before the court decides on asylum application. What the asylum seeker, rejected asylum seeker, can do in those circumstances, of course, he can appeal. Here, the appeal is to the Office for Foreigners, so see, to the authority who made the negative decision in asylum procedure in his case. However, different department, but that's the same authority. And next, he can approach the court. Suspensive effect is attached to the first appeal, but before the court, again, it has to be requested. However, this request is, at least for now, suspensive. Polish authorities are planning to change that for the non-suspensive request, but we will see whether it will change or not in future. Yes, and then suspensive request, the suspension is valid until the judgment of the court as regards the suspensive effect. The problem is that in 2018, the interpretation of the court has changed, because before 2018, it was quite obvious that in return court proceedings, suspensive effects would be granted. It with very, I would say, rare exceptions, but in most return proceedings before the court, this suspensive effect was granted because it was assumed that if it is, those are return proceedings, so irreversible harm is going to happen if the person is going to be removed before the court decides on the appeal. However, it changed in 2018, and now the court emphasizes that there has to be some special individual circumstances. The applicant must make the effort to show that the irreversible harm will really happen after if the removal is to be enforced before the end of the court proceedings. I would like to end with the situation of dangerous asylum seekers. By that, I mean persons who are considered in Poland a threat to Polish security, to public order. Basically, I can make the observation that they do not have the right to an effective remedy in Poland because they are dangerous. Unfortunately, it concerns a really great group of people. As you can see, only in 2020, last year, 564 return decisions were issued in Poland for security reasons. Not of all of them concern asylum seekers, obviously, but still it is a great number of people who are considered to be a threat in Poland. And what are the consequences of such decision? There is no period for a voluntary return. Such decision is immediately enforceable, and most often the removal is enforced very quickly. Appeal is available, but there is no suspensive effect attached to it. There is no request to ask for suspensive effect. What makes appealing in those proceedings even more difficult is that the decision that the asylum seeker, return decision that the foreigner or rejected asylum seeker receives has no reasons. it only states that the foreigner is threat to Polish security and public order. It states the rules of law which apply, but does not have any factual justification. There is no access to evidence given neither to the asylum seeker, neither to nor to his legal representative. Basically, there is no way to know if you write such appeal why this particular person was considered to be a threat for Polish security. So those cases are very difficult to handle. So I would like to end with the question whether remedies in Poland in asylum-related proceedings are really effective. And we already know that refusal of entry proceedings do not offer effective remedy as understood under Article 13 of the European Convention of Human Rights. As regards asylum and return proceedings, I would say that in general, they offer effective remedies, but in very particular circumstances of the case, there will be cases where there is no access to effective remedy, in particular when the asylum seeker is considered to be dangerous. There are some pending cases as regards return proceedings and the lack of access to suspensive effect in those proceedings in case of dangerous persons. So hopefully, maybe not soon, but we will learn maybe in some time what the European Court of Human Rights thinks about that. And maybe something will change in Poland for better. Thank you very much.
Thank you so much, Maya. So I'm trying to remember questions to ask you, and I advise everyone else to also do that, because now we need to have the second presenter ready. So I will introduce Sasha Brown, and after that we can have a discussion about both papers. And it was really interesting to hear about Poland, and I need to remember some questions for you. Okay, so Sasha, who will be the second and the last presenter in this panel, has a very fresh PhD, I guess, in geography from Maynooth University in Ireland. And he will give a talk with the title Assessing Cultures of Practice in Asylum Decision-Making Towards an Analysis of Variation in Refugee Appeal Decisions in Ireland. And Dr. Sasha Brown recently finished his PhD in geography and is now a postdoctoral researcher at Maynooth. Sasha's PhD is titled Evidence and Absence in the Archives, a study of the Irish Refugee Appeal Tribunal Archive, Appeal Tribunal Archive to assess the state practice of determining asylum in Ireland. Sorry for that. And it explores the evidence and absence of evidence in Refugee Appeal Tribunal Archive. Sasha is also now working on the 5-Star S, Space Surveyors and Students project. And his work includes community mapping, creative use of digital research method, and the application of web scraping method in political geography. Extremely interesting field. So we are happy to have you here. And Sasha, you would like to share your screen as well?
Thank you very much, Livia. Let me just get set up here. Okay, can people see my screen now?
Yes.
Great. So yeah, a couple mouthfuls there in some of my research, just trying to capture all of the kind of different parts of it, and so today I hope to present this paper, which is about how I've assessed the culture of practice in asylum decision-making in Ireland, and how I've done that through an analysis of an archive of the Refugee Appeals Tribunal and an archive of their decisions. And so I'll start off with this photo, which is from Asylum Archive. So you can find, I'll use some of the photos through this project. Asylumarchive.com is a really powerful archive of photographic evidence of the treatment of asylum seekers and refugees in Ireland. And this here is one of the offices of the Refugee Refugee Applications Commissioner. You can see it from the outside. They have these papers up. So I present this paper, an analysis of the practices of the International Protection Appeals Tribunal in Ireland, and that's the tribunal that assesses appeals for refugee status and appeals generally within the asylum system, and also appeals for subsidiary protection and appeals against other negative first instance decisions from this Refugee Applications Commissioner. So I've done this research by analyzing the large archive of the Refugee Appeals Decision of Refugee Appeals Decisions issued in Ireland, the Appeals Tribunal Archive. The Appeals Tribunal Archive was first opened to researchers in 2014, and I began my PhD in 2016 at a really time to start researching this archive, seeing what can be done, and researching through the archive the practices of asylum determination in Ireland in this specific way. So I think that this research relies on this kind of somewhat unique archive of decisions that doesn't exist everywhere, or it's not accessible in many contexts. And I argue that by having this archive and engaging with it through research and different research methods, we can see what the archive contains and does not contain, and how it can provide a unique insight and a way to study patterns of asylum determination. And I propose also that where these archives do exist in other countries or contexts, there may be this opportunity for some comprehensive and important analysis of cultures of practice in asylum decision-making. Although archives can never fully capture all that we want to study, and should also be carried out, the research of these archives should be carried out in concert with and complement other research methods, qualitative, quantitative research methods that we've heard so much about in this conference. And I think it can really be something like, when we are working together, kind of studying these practices can be really rewarding. So the structure of my presentation, I will first present my theoretical framing around my project. I then will explain some of the context of asylum and refugee politics in Ireland, explain a little bit about what the Appeals Tribunal Archive is and how I carried out my research. I'll then present some of my findings that I've made from the archive so far, and some of the decisions and how some of those findings came from decisions I made as part of what became the project, an ethnographic and participatory structure of investigating an archive. And I'll talk more about that, of what the outputs of my research, what I hope for them to be in the coming times, trying to publish from my PhD and get some of the research out there. And so one output that I'll focus on is, and we'll have the time now to explain more fully, is a comprehensive reporting of the archive of the systematic practices of the tribunal and the individual tribunal members who issue the decisions. However, I also want to open up and hopefully engage in a conversation around how ideas of how transparency and fairness can be advanced and developed theoretically to imagine what kind of asylum determination process we are seeking when we critique existing border policies and the existing refugee status quo or milieu or regime in Europe. So my theoretical framing, we'll go back to that one. generally focuses on this method of studying the state that Alison Mounts talks about. Research in feminist geopolitics has been challenging the state as a preconceived entity and has studied how the practice of those performing the state, whether in structures of governments, elected positions, bureaucrats, or others, are enmeshed and entangled within larger communities and societies. Mounts and others challenge the notion that the state is a preconceived entity. State is performed and performative, and the image of state comes about through the acts of statecraft. These literatures also call for more empirical fieldwork to investigate the everyday actions and rituals of statecraft and for an open discussion on how this fieldwork can be done. And so Mounts writes, while civil servants work furiously to manage human migration, social scientists must work hard to trace the changing nature of sovereignty and the many contradictions involved in its exercise and border enforcement. We must write our way to and through the state to understand just what kind of state we're in. And so as Mounts and others write, border enforcement is a major kind of statecraft, where state actors are one of multiple situated subjects in a power geometry of contested production of formal and informal practices and spaces. Border enforcement happens not only at the physical sites of borders, but also in detention centers and in the offices of government government agencies, where people are every day making decisions about inclusion and exclusion to the sovereign territory. It is in these spaces that state agencies craft narratives of certain types of border crossings as threats to the security of the state. And Maya spoke a lot about that. It was really interesting to hear how that's framed in Poland, and work to minimize the narratives of threats to the security and well-being of migrants. This project investigates the practices of the refugee asylum determination process in Ireland, and I use this archive of appeals decisions to investigate the systemic patterns and cultures of practice in the determination of process as looking at it as border enforcement. So these archives are important, and I draw a lot upon Anne-Laura Stoller's work. Her work focuses on studying a 19th century colonial archive, the Dutch colonial archive of colonial holdings in Indonesia, and she carried out an ethnography and a sustained engagement with the archive. So I do argue, I make this argument that this archive, the Appeals Tribunal archive, has its origins both in the history of archives used by states, this kind of colonial past of how nations used archives to organize their states, to organize how they stood, how they understood the nation, and also very important to the colonial, how they carried out their colonial ventures. So I'll just have these quotes up for a bit. And also how archives today are very much digital and very much have a different form. And so by combining methods of what archives are now and the history and where they come from, their genealogy, I think that geographers have used to look at colonial and look at modern digital archives, we can make what I think are emancipatory methodologies to study along the grain, as Stoller puts it, of the digital neocolonial state. So Stoller's work in archival ethnography, studying along the grain of state archives, focuses on the anxieties and sentiments of civil servants, how they take the logics that they interpret and anxiously arrange to carry out what is, in their view, the duties of the state. This is in the context of the archive that she's studying, but I think there are connections in how archives can show and be sites of how knowledge is produced. And so I have this quote from Stoller here: scholars should view archives not as sites of knowledge retrieval, but of knowledge production, as monuments of states as well as sites of state ethnography. This requires a sustained engagement with archives as cultural agents of fact, production of taxonomies in the making, and of state authority. So because the work of border enforcement is in the office of state agencies, it's everyday, and it's an everyday violence, and some patterns of these practices can be seen in the archive. The violent acts of deportation and border enforcement become normalized as everyday occurrences, as paperwork, as evidence to be submitted, or as claims with, quote, solid evidence. Also, Coleman and Stuest often discuss how difficult it is to study these moments of border enforcement often. And they discuss specifically in their study of traffic stops, border traffic stops in North Carolina, how often these border events are quasi-events. They are below the threshold of an event to describe, and they use this concept from Pavanelli of the quasi-event to describe the fleetingness and fluidity of power when state power is produced as everyday. So for us, for researchers, it's been difficult for us to see or to prove the systematic practices and patterns in these events of asylum determination judgments. And so by invoking the colonial, I hope to gain insight and make some connections in studying that kind of systematic patterns and cultures of practice. Do state bordering offices today in Europe operate drastically different from these colonial logics? From this case, whether in Ireland from the British Empire bordering offices, or in Stoller's case, the Dutch colonial offices. And so kind of more generally, colonial is often invoked in history and studying colonial and in other fields with such like a certitude of its effect by those studying it often, and colonial memory with such assuredness of its ever-presence that both are treated as known and knowable quantities rather than as problematic sites of query in themselves. So I hope in looking at this connection and in seeing if there is a connection between colonial logics to contemporary border practices to bring critical attention to understanding both of these contexts. And so on to my own context, asylum in Ireland. I have here very similar statistics to Maya, just in a map form, which I thought would be interesting to see. These are statistics from Eurostat, which, as Nick Gill spoke about earlier, is not always a perfect measure, but is often good to get a start of kind of understanding the bigger picture in Europe. And so this is the percent granted in first instance asylum decisions. So you can see here Poland and Ireland with a very similar percent granted, very low and also low in comparison to other countries. This is for the years 2008 to 2019, so it's kind of a range of years. And Ireland also receives, in comparison to many other countries, very few applications for asylum. It's often, it's mechanically very difficult to get to Ireland without permission. Most asylum applications in Ireland are made at the airport. And so here's asylum applications in Ireland over time, going back to 91. As you can see, before in the early 90s, they were almost close to zero in comparison to a spike in the early 2000s. And again, a rise coming to 2019. And sorry not to include 2020, but I believe like many countries, they are lower. And this here is the organizational chart of the asylum agencies. So we have here the Minister for Justice and Department of Justice. And in Ireland, the appeals are handled by a tribunal. And so rather than being within the courts, though judicial review can be sought for the tribunal, this tribunal operates within the Department of Justice. Now it does have kind of a semi-independent nature, but often the Minister for Justice can make significant kind of changes and to the tribunal, especially when the tribunal is in the news. It often falls on the Minister for Justice to kind of sort that out. So we have here on the right the Refugee Applications Commissioner, or now the International Protection Office, recently changed, issues the first instance decision, and then on the left here, the separate column is the agencies in charge of the accommodation service and the reception, the system for asylum reception in Ireland, called direct provision. And so that comes to the Appeals Tribunal archive. So I have here just a picture of myself accessing the Appeals Tribunal archive. It was first presented outside of the Department of Justice in 2006 when the Atanasov case determined that there was an inequality of arms. So Department of Justice officials had access to all previous appeals decisions, while asylum seekers and their reputation did not. And so the database of appeals tribunal decisions was made available to solicitors involved in representing their applicants in their appeals. And interestingly, for this project, there was another appeal the year later in which asylum seekers sought the decision rate of the decision rate of tribunal members, how tribunal members on the tribunal were issuing and their percent of recognition or refusal of appeals. And they knew in this application that there were decision makers who were issuing negative appeal decisions in all or almost all of their decisions. And so they were really saying, we would like to figure out who that is and make an argument for those people not to be making, my decision, like not to want to go in front of them. So that didn't happen at the time. It was settled out of court. But in 2014, a judge of the Irish High Court quashed an exceptionally egregious appeals decision, which she described as unfair and irrational. So she was taking a single court case and saying this is especially bad. And she wrote that sometimes the court is called upon to review a decision which is so unfair and irrational, contains so many errors, that judicial review seems an inadequate remedy to address the wrong perpetrated on an applicant. This is such a case, end quote. So there really was this case where judicial review, which can only be kind of technical reviews of appeals decisions, she was identifying it as, this is Judge Maureen Harding, as not enough to merely quash the case, but rather she, as part of the judicial review, she mandated that this archive of decisions be open to public researchers. And now to this day, any person can email the tribunal to request a username and password to access this database. And so that's what I did at the beginning of my research. And I came to the archive. It was a very active discussion at the time. What can we learn from it? How can this provide actual equality of arms, actual transparency, actually something to ensure that this processes can be fair? And I worked in my research to have formal and informal communication with groups of asylum seekers and advocacy groups around what are the important ways that this type of research can be used and can be examined. And I came back to Mounce's question from earlier: how can we as social scholars keep up with the changing tactics and patterns in the state process of bordering? And I argue that this archive can help. That is, what does the archive contain? It contains most of the appeals decisions issued 2005 to present. Currently, there are around 17,000 decisions in the archive. And new decisions are added over time. Each decision is recorded, as you can see here, by date, type, country, outcome, reference number, and though it doesn't contain the name of the deciding tribunal member. Most decisions in the archive contain a written PDF of the decision, these decisions are often around 20 pages. And so a big part of my research was choosing a subset of decisions to read and to qualitatively analyze. One of the early steps that I took was a process called web scraping, which I can talk more about if people are interested in the questions. But for now, I'll just say I set up a script to collect all of the entries that are in this archive, a very difficult archive to navigate if you're looking for actually, kind of statistical, analysis, or looking for larger data sets of decisions. And was able to see what was in the archive. So these are two kind of graphs. They are perfect for viewing, so apologies if you can't see it, but the one on the left here, decisions in archive versus total, is a rough measurement of how many decisions are in the archive versus how many are the appeals tribunal has stated in their annual report that they issue. So you can see that before 2006, they actually state that they don't include all the decisions in the archive, so it doesn't go back that far. It contains only a small set of cases. Since then, it contains most of the cases, but not all of them. And so often they say that they remove ones where appeals tribunal decisions have been overruled in judicial review. And also, I think there are some other reasons that I'm not quite sure about as to reasons why they remove them. And so now I'll come to kind of what were the outputs of my project. So one output was saying what are the decision rights by tribunal members? How are individual tribunal members acting on the tribunal? Oops. So as I said before, the kind of overview, the metadata does not contain the name of the tribunal member. Just lost my space in my notes. However, this here is an example of a PDF of a decision, the last page of the decision, where there's the conclusion as well as the outcome of the decision. So in this last sentence here, the tribunal member Ben Garvey is setting aside the recommendation and granting refugee status against the first instance decision. And as you can see here, this is issued by the tribunal member Ben Garvey. So if you're familiar with PDFs, you can kind of see that you can I have here much of the text highlighted, but when you highlight the text, the name of the tribunal member doesn't appear. So it was a little bit more difficult than just kind of highlighting, converting a PDF to text. I ended up using some of the optical character recognition, OCR tools to identify who the tribunal member was in each case, but was generally able to do that after some work. And so I've created this. As you can see, there are really wide variations in how tribunal members in the tribunal member decision rates. And so this is, again, this period 2006 to 2018. And you can see that they range from 40% refusal on appeals to 100% refusal, refusing all cases. And so also in a more recent, in this time period, here are decisions issued 2013, 2018. So these are just tribunal members who have issued more than 30 cases. And you can see that there's still this really drastic kind of variation. And just to point out here that Hilke Becker down at the bottom with a very low refusal rate, a high recognition rate of refugee status, is actually the chairperson of the tribunal. And so it was really interesting to find that tribunal members were acting very much not in step with the chairperson of the tribunal, and actually much harsher. Also, when the chairperson of the tribunal member took cases, it was over 50% overturning of appeals cases of the first instance decisions, which is really high overturning of an indicative of kind of the process that we can't see, the first instance decision, which we don't have access to. This generally kind of parallels research done in other countries. There is the work on refugee roulette in the USA, and Sean Rehag's work in Canada is generally framed around this luck of the draw of saying the main influence in a case's outcome is who is making the decision. And so this is really interesting. In Ireland, another thing is the allocation of cases. Tribunal members work piecemeal. Like by that, I mean they are paid a set rate for each case, and cases are allocated by tribunal chairperson in a process that is like not really well known. It's not really known how they allocate these cases. And so in the 12-year period, this 2006-2018, we can see how 10 people decide actually over 50% of all of the appeals tribunal cases. And now during this time, there's 110 tribunal members, and only 10% are issuing over 50%. And as you can see here, the refusal rate is generally very high, generally very harsh judgments. And so this kind of number of decisions made by, this is something we knew before. It was in the annual reports of the tribunal member, but of the tribunal. But now we can see kind of from this research that all of these people have quite high refusal rates, above the average, and very far away from the norm of the chairperson. And this poses the question, how are these cases allocated? And again, that's not really well known. I also used a metric that Sean Rehag in Canada used in his work, this predicted refusal rate by country of origin. So this is a normative assessment kind of tribunal members' practices, and trying to normalize, okay, if we take out the different variables, can we see how they can continue making this normative judgment? So in this case, it's saying if a tribunal member were to make the average decision rate based on the country, based on the countries where the applications that they're deciding on with country of origin, how would they make decisions? So you can see how they differ from this other kind of measurement where you can see Michelle Gorman making the most number of cases. if she had made, the average number of refusals based on the countries that people were from, she would be issuing a refusal rate of 88% and instead has a refusal rate of 95%. So you can do this with various different variables kind of around the type of case and kind of continue making these normative assessments of what the variation is within the tribunal. And so what are the responsibilities, I think, as studying this termination system? And from looking at decisions, how can this process be more fair and transparent? What are the obligations that can be attached to this kind of work? Well, first of all, I think this should be a beginning because there's a huge amount of work that can be done just from these normative assessments in this archive. And there are not many countries where these are all available. So I think it's a really interesting opportunity to do this kind of research. And just kind of another finding, I'll check the time and see, is another thing I was able to find from this kind of research was this case of the tribunal member Nero Morgan Pillay, who issued decisions between 2008 and 2011. And so just to explain a little bit, in a court case in the Irish High Court in 2014, Justice Barr ruled that this tribunal member was making a judgment that was inappropriate. So you can see here that the tribunal member Pillay states that Professor Hathaway, James Hathaway, makes argument in this book that those who, here I quote from the screen, those who truly fear return to their state ought reasonably to claim protection in intermediate countries of potential refuge. It makes this argument from that if someone was not arriving from the country that they came from straight to Ireland, which is very difficult with the way that flights are, that they wouldn't be considered credible. And so on the right here, we can see the judgment from Justice Barr that says the second quote is not a statement of Professor Hathaway at all, but rather something the author quotes at page 49 from his book and Professor Hathaway immediately follows his quote by saying, fortunately, the Court of Appeal has intervened to constrain this implied direct flight rule. The applicant submits the quotation which have been included in the decision are the very antithesis of Professor Hathaway's view on the subject. And so Barr overruled this, quashed this tribunal decision and left it at that. However, I found that this research, as you can see below, that this wasn't the only time that the tribunal member Nero Morgan Pillay had used this logic. And I found these misquoted sections I found in 109 decisions, so in 108 other decisions where this had been improperly used, almost half of all of the decisions. And so really this is showing kind of some potential of the archive of what can be done of looking for these kind of patterns that can't be seen from looking at one case at a time. And so kind of coming to the conclusion of my presentation, I think even without, I think there's a big potential from this archive, and that's, having worked on it a while, I still feel like it's the beginning of what can be done. And I wonder if there are other countries where appeals decisions can be publicly accessible and collected, and this kind of work can be reputed. And also a focus, I think there should be a focus on the people doing this work, and that this should be a public-facing role, as it is in some countries. Right now, tribunal members in Ireland can be hired with kind of little experience. It's not a civil service job or a judge job, but rather contract work. And these are really huge decisions, and people should be making them accountable to professional rigorous standards and public service standards. And so from the decisions, we can see what we don't know. Why are some people receiving so many decisions? Why is it that these people are receiving so many decisions are likely to refuse appeals in contrast to the rates of some other people? And more generally, kind of, can this archive be a place to start conversation about what should be available and what should be kind of public information? And also, if we're thinking about what a fair recognition of for applications of asylum, can we embed and include a radical rethinking of what bordering is and how current bordering practices by European states produce migrant lives in certain ways in the rhetorics of the state knowledge, like we've seen from other presenters. By bordering, I refer to how in migration and border enforcement, states exert these extreme versions of power, limiting movement, detention, and deportations, especially in cases of assessing claims and applications for asylum. The border becomes a practice of bordering in many places. And the bordering practices that states engage in are not just strategies of domination that emerge whole from within the state, just as these effects of these practices are not simply outcomes that emerge from within immigrant communities, is precisely this interface or encounter that I want to focus on in these decisions that is really important to study. And if we're to analyze these state knowledges, it's crucial to critically analyze the normative judgments these state actors and civil servants are making. And also to propose our own models of what asylum can mean. And I kind of bring up this point of when you criticize a system and say that there are mistakes being made, I want to be kind of clear about what kind of assumptions and kind of we are making, that when you criticize, you're also exploring what we are imagining in these criticisms, what a fair process is. I argue that these should be liberatory imaginations in the mode of imagination suggested by Alison Mounts and Pavanelli and others about what can be. And so I've been talking for a little while, so I'll just wrap up, but just from my own empirical work, studying the Appeals Tribunal archive, one of my aims has been to work see if this archive can create a more transparent view of the practices of the Appeals Tribunal by creating this database of tribunal member decision rates, and to also make a publicly available resources from and of these previously hidden and undisclosed information. And that there is an opportunity here to think about how asylum determination can be an open process, and should be possible to make analyses of these normative judgments of these agencies and of variations in judgments by different decision makers. So thank you very much, and I'll end there.
Okay, thank you so much, Sasha. I think this can start off a really extremely interesting discussion.